Welcome to the Building Doctor Show with Jens Johanson.
Welcome to the Building Doctor Show, everybody. I am your host, Jens Johanson, and I'm glad to see you here to learn more about your buildings today. Today, we're going to be talking about attorneys and specifically HOA attorneys. And so the differences, sometimes we'll talk about construction defect attorneys or insurance recovery and claim attorneys. And today is specializing in HOA attorneys. So as you know, your HOA or your condominium is a legal entity that is responsible for running your property. And they will need an attorney for legal experience, for collection efforts, for contract reviews, for dispute resolutions, and governing things and compliance things to help you run your building better and more efficiently. So today we're excited to have Amy. And Amy, are you able to turn on your screen and video? And there we go. There she is.
Hey there.
Welcome to the show, Amy.
Thank you.
Amy's a partner at the Laurel Law Group, and we're going to talk about how having an HOA attorney in your corner is beneficial to you. And the best part is at the live Q&A at the end of this, you'll be able to get to talk to an attorney for free, right? So tell us a little bit about yourself, Amy, and why you wanted to be on the show today.
Sure. Thank you. Thank you for having me. As Jess mentioned, I am a partner at Laurel Law Group. We do have a practice area that focuses on representing, I call it community associations collectively for, HOAs and condos. Mm-hmm. We're located in Western Washington. So I am a Washington licensed attorney. I've been practicing law for almost 20 years. Mm-hmm. And most of that focused on community associations, some other fun little things, like family law, but just, and civil litigation, which has really helped my condo or HOA practice. I am also a member of the Washington State chapter of Community Association Institute. I have participated, in educational seminars. I've written some for some articles for its magazine. And then interesting point, Jens, I think you and I have been working together on various building projects for over on and off for over the last 10 years. So we have a history together, which is great. I wanted to come on the show. I think this is a fun way of connecting the audience with information related to community associations, and hopefully you get some good information out of it.
Yeah, awesome. Yeah, one of the things I've always appreciated about Amy is that she is pleasant. She's pleasant to work with. She's fun. But I've seen her, you do not want to be on the other side. When she gets angry at somebody, watch out, run. So anyway, she'll make it fun. So we are going to run our poll. As you know, we like to tailor our answers to make sure that we're, talking to the right groups. So we're going to put that poll out there. If you'll take a moment to fill that out. And while we're talking to you, just kind of the disclaimer section, whenever you have lawyers involved, we just have to say the show is for educational content only. We're not giving legal, financial, or engineering advice, and I'm not a medical doctor. And we're not selling anything. So put your credit cards away. We're just people on the internet trying to help you run your buildings better. And we've seen what's worked for thousands of people with their building problems. And we want to share that with you in hopes that it benefits you. And if it does benefit you, do us a favor, like it, subscribe, follow, comment, wherever you're watching this. If you're on the live, you can still comment in that, but later it'll be on YouTube and other areas. So share it. This helps us expand our reach. So let's jump back into the polls and see where everybody's at. There's a lot of people in Washington, Oregon, managers, board members. How'd you hear about the show? That's good. Have you ever been through a repair process? Yes, 60+% of you have been through it. So there's the results for people. So the live details are, stick around. This is the live part of the show that's so much fun. At the end of it, we have a Q&A, and we know it's Tuesday at 3:30. It's hard to be here live, but we appreciate the everybody in attendance. 130 of you are signed up for it, and so the replays will be good as well. But stay tuned for that live section. We'll also be doing some giveaways. Brooke and now Ben will be monitoring the chats and Q&A, so welcome them, and they'll make sure that we get our questions in that Q&A panel. So again, questions in the Q&A section, and chats are kind of more for us distributing things. So stick around. All right, let's get into the show. Oh, first, Amy, do you have any good lawyer jokes? Is now a good time for lawyer jokes? What's your favorite lawyer joke? Amy?
Oh my gosh. I don't do lawyer jokes. I just don't.
Good. I was trying to catch you off guard, and
I know
that's
you
okay.
did, but
All right.
I just don't do them. I've heard them being made fun of, and I pretend I'm not a lawyer when I hear them
Right.
and chime in,
So it's
because
kind
it's
of
funny.
hard. It's like, I'm glad I'm not one. Yeah. All right, we'll move on. No lawyer jokes. Okay, so today's agenda, in today's show, frankly, like any of our shows, is brought to you by questions that get submitted to us, or questions that we are hearing in our day-to-day operations. And a lot of the questions we hear is, hey, why do I need an attorney? Aren't they expensive? Is this a pain? What is a CC&R? So we're going to start off by kind of defining CC&Rs, covenants, bylaws, governing documents, and everybody's going to argue about this, but we're going to kind of put it together into a package, and Amy can tell us some of the differences there. And then number 2, what do HOA attorneys do specifically, and why should we have one? How do we effectively use our attorneys' time so that, hey, they're expensive. So how do we keep them, moving along efficiently? When to call your attorney. And this will be a fun one. Issues that have become more common since 2020. You can probably guess, but that'll be a good one. Hey, I'm putting together my budget for the first time. How much do attorneys really cost? We can give you some kind of guidelines there. Common bylaw revisions. So your bylaws or documents are probably old. They probably benefit the developer. Here's some real common ones you can do. And then interview questions for hiring an attorney. We've got a few tidbits there. But then this is a fun one. Nightmare stories and disbanding the HOA. Amy and I have worked through kind of a big one. And we'll talk to you about, is the grass really greener? Should we really disband the community and go back to just single family homes and that type of thing? So stick around for that. All right. Definitions was kind of the first one. So let's just briefly talk about definitions. What do you define definitions as, Amy?
Oh, sure. So the governing documents of the association involve many different individual documents. Usually you have the documents that create either the condominium or the HOA. And those involve 2 primary documents. For an HOA, it would be a plat map, and then your covenants, conditions, and restrictions. Those are recorded with the county recorder's office, and they bind all subsequent owners and purchasers with respect to their restrictions. So they set forth, the things that, they form the association, but then set forth what an association can do, what terms, or conditions of use, what is restricted, what's prohibited. I failed to mention for condominiums, it's the survey map and plans, and then they have the covenants, conditions, and restrictions. Other documents that govern associations are your bylaws. Bylaws really contain more of the administrative functioning of the association. So they will describe, like, for example, meetings, what kind of notice is required, what constitutes a quorum. So in order to do business at a meeting, you have to have a quorum. It's a minimum percentage to do business. How to conduct like a special meeting, what type of notice is required, who can call
Mhm.
it. So those kind of functional things, running for the board, who's qualified, terms of board members.
Okay.
When can, the membership, remove a director, and how does that work?
Right,
Uh,
right.
yeah,
Right.
yep. So there's,
So as far as talking about them all at once in a nice package, are we wrong saying, hey, look at your governing documents? Because that's kind of the broad or bylaws or CCNRs. How should we say?
I would say look at your governing documents. I mean, primarily you want the documents, the either the plat map or survey map and
Mhm.
plans, and then the covenants, conditions, and restrictions, because
Mhm.
those documents will supersede or take place of any other of the, I call them like the lower level documents. So if
Gotcha.
they have a provision in it, that is, more restrictive, but the bylaws conflict, the CCNRs or the plat maps would supersede the bylaws.
Gotcha. Okay,
So,
cool. So from that standpoint, yeah. Okay, awesome. So
yeah.
now all the managers on here are going to be debating and arguing. No, I'm joking. But if you're a board member and you don't know the difference, there is a difference between these things. And that would be a good reason why, you'd want an HOA attorney to help you with that governance, to help you with, what document do I use? How do I remove a crazy board? Or, what do we need to do here as far as voting? So,
Right.
what does an HOA attorney do for the association? I kind of hinted at those 5 things in the intro, but, go for it. What are the things you like to do or that are important to do?
Yeah, it's so primarily we work with the association's board, and if there's a property manager, also the
Mhm.
property manager, and in terms of governance of the association's affairs. So it's a very, very broad range of things.
Mhm.
It can be, something pertaining to the day-to-day operations. It can be collection of past due assessments, or like
Mhm.
even establishment of a collection policy.
Mhm.
It can be enforcement of the governing documents. If you have, an obnoxious owner who paints their house bright purple and it doesn't, comply with the association's, um, standards. So there's like community-wide standards, or there might be actual, um, like a painting palette that they're
Mhm.
required to follow.
An
It would be
architectural
something.
review board. Yeah.
Yeah, it'd be
Mhm.
something like that. Also, attorneys tend to be the fall guy. We handle, or fall gal. We handle difficult owners, difficult opposing counsel, and just those types of situations where it's like, wow, can you help us, Amy? This owner's being really difficult. They're harassing the board. And I'm
Right.
like, absolutely. I'll send them, a cease and desist, and have them, contact my office directly if they have continued issues or things that they want to bring to the association's attention,
Right.
but also that they need to do it in a courteous and civil manner.
Yeah. So
That kind of stuff.
board members have to live next to them. They've got to go to the mailbox together. And sometimes you're like the baseball manager, hired to be fired. And so it's you go do the dirty stuff, the mean stuff. I need to be a neighbor. And so, okay. Yeah, that's another place.
Sure.
I'm assuming contract reviews, all that kind of basic stuff, or
Yeah, definitely. Contract
hiring.
reviews, governing document reviews and amendments,
Mhm.
drafting rules and regulations, and those typically govern owner conduct. Got to pick up your pet waste, quiet hours, or during this time.
Mhm.
Updating associations on new laws. There's actually been quite a bit of legislation, at least here in the state of
Right.
Washington, over the last couple of years. And
Mhm.
so we're constantly getting reports from the state, updating us of what's going on with respect to those
So it's
laws. So
kind of like taxes, the tax law changes, the condo law changes. And so if you're an association that hasn't had a review or hasn't worked with an attorney for a while, you're probably about 6 generations of law changes behind. And it's good to check in.
absolutely.
Yeah.
Absolutely. Otherwise, it's like running blind, and I've seen associations not properly adopting their budgets even, just because
What happens when that happens? When there's an illegal vote and an improper adoption, what happens? Can people get out of the assessment?
Well, that would depend on many different factors, but potentially that could be an issue. And owners become upset when they think that the association is following a particular process that was incorrect, and then you change the process, and they think that the association is doing something wrong. So it's upsetting, and it can lead to conflict, potentially litigation, even though the association is now trying to go on the right path.
Yep. Okay. All good questions. Let's go to the next one. So, how to effectively use your HOA attorney. You talked a little bit about that, of enforcing policies and mediating disagreements. What does training or insurance deductibles mean, or good property managers and consultants?
Sure. Well, if usually a property manager will be able to provide the board with some good training. Property managers don't always have all of the information, or like the current laws or things that may be helpful in helping the board with their procedures. But part of that would be establishing policies, maybe advice about what to say or what not to say to owners who are in collection, for example. And other matters can involve how to handle difficult owner meetings, how to address the membership, especially sometimes we get very vocal owners who they're really upset, and just trying to be reasonable but asking them politely to be courteous, and and then having the policies to fall back on that. So it's like, hey, if you're asked three times, you're out of the meeting, that kind of thing. So assisting the board to get them, ready and prepared for those kind of situations. With respect to insurance deductibles, that can apply, in terms of a question of, hey, can I assess this deductible to an owner for this loss, or is this something that the association needs to absorb? So effectively using your attorney, sometimes managers aren't even really sure. It just kind of depends on the situation, and it depends on the governing documents. But so it's always good to reach out and say, hey, is this something we can do? Who's responsible? We need a little bit of input here.
Yeah, a couple episodes we had an insurance broker on, and we talked about the third floor had a flood and it affected second and first floor, whose policy pays for what. And some of these things are common elements, some aren't. And so I think what the insurance broker was saying, it's all per the contract or the insurance policy, and having somebody like yourself allocate that or explain how this is going to go down.
Absolutely. And then on that last point is directing the association board to the resources it needs for this situation. So if I have an association that, let's say they're coming up on a potential statute of limitations issue for a construction defect claim, and maybe they've had a visual inspection, and, sometimes things look, well, this building's only 3 years old, but it's kind of showing signs that this wasn't well constructed. I'd recommend them, to you. There's other issues involved, like maybe a geotech is needed for, a land erosion issue. There's all sorts of resources that associations need. Just so as I'm a resource, directing the board or the property manager to good resources to handle the situation. Yeah,
good. Okay. When to call your attorney. And so here's some bullet points. And I think one of the first ones is, so it's a lot like we'll say as consultants, you don't need a consultant to paint the fence. Just call a painter, take care of it. And so this first one is, look, you're not here to do the first steps of, negotiating and issuing notices and things like that, but now that we're on step 3 or 4, now we can bring an attorney in. And so this gets back to the efficiency question of, you're not doing all the work for these people and they can't abdicate everything of management to you, but talk a little bit more about that.
Sure. I think an important part of, this first point addresses either collection or enforcement issues typically. And so it's really important in an association for the board to follow the processes set forth in their governing documents. So there's usually like an enforcement or collection policy. And if it's really not an emergency, it's quite unfair to an owner to have like one notice sent and who knows what happened. Maybe they missed it in the mail. Sometimes that happens. But then all of a sudden they're hearing from an attorney, and that feels quite unreasonable.
Yeah.
And, honestly, if it's litigated, it can appear unreasonable to the court, and the court might document some attorney's fees for that, even though ultimately the owner didn't comply. So it's really, really important to try to go through those first steps. I mean, obviously, if there's a question about what needs to be done, definitely call the attorney. But fulfilling those steps is definitely a good thing to do. But then obviously it's like, okay, we've done what we're supposed to do, and they're just not doing it. We really need your assistance.
Yep.
That would be, yeah.
Okay. And then legal proceedings, we've got bankruptcy notices, that's foreclosures or things like that. We've got liens and threats of liens, or even lawsuits, against the board or between residents or neighbor to neighbor, that kind of thing. Insurance claims, we talked about a little bit, but really understanding, kind of when you get lots of different parties, they kind of all look at each other and expect the other party to do something. And sometimes they need to be told what to do. And sometimes an attorney letter with attorney letterhead kind of motivates them. So
yeah, that's really true. Yeah, definitely any type of legal notice, bankruptcies can affect what an association can do because of the bankruptcy stay. So it's important. It's like, ooh, bankruptcy notice. Stop the delinquency letters, stop the violation notices, contact the attorney. With any litigation, there's deadlines also involved. So that's important to get in front of the attorney so they can protect the association's interests. We talked about there's a statute of limitations deadline. That's one of the bullet points. The statute of limitations is the amount of time that a plaintiff has to make a claim against the other party. And so let's just talk about collections for a second. In Washington, it's 3 years for condominiums, and then for HOAs, it's 6 years. So as you move forward in time, you lose the right to collect those assessments that are 3 years or older. Older than 3 years for condos, or older than 6 years for HOA. So the association is losing its ability to collect.
Okay.
Yeah, so those are really important things to look out for. Resale certificates and seller disclosures. Property managers and boards it's important to update those things, particularly if you're aware of damages or huge repairs to the buildings that potentially there might be a special assessment, but obviously would impact a prospective buyer. It's important to disclose those things. There's other things that need to be disclosed, like pending litigation. So it's always good to contact the attorney. Hey, can you help us with the resale cert? And make sure it provides the information needed.
Okay. What about squatters, or somebody's kind of broken in and they're inside? Is that more of a police issue to kick them out, or is that called the attorney because we have to deal with them specifically? Are there rules around that? I'm thinking major metropolitan areas, somebody's broken in and they're just living there.
Yeah. Those are interesting, and they're also kind of complicated issues. So I guess the first question is, the owner, obviously it's a vacant property, it seems like the owner can be, it's a huge burden to the association because the owner's the one who is really responsible for like a quiet title action to have them removed, or some other form of legal action where, you know, a writ is issued and the sheriff can come in and remove the squatter. It's a little bit more difficult for the association. It depends on what provisions are available in the governing documents, but it's, you know, it's also really expensive. So it's kind of the plan of attack could depend on, you know, like I said, the provisions, how much, you know, the association wants to allocate. Unfortunately, I've seen law enforcement really not having the resources to respond.
Right.
Occasionally they will, but it's been very difficult, and it's put a huge extra burden on associations that can be very expensive. So
Yeah. Okay.
yeah.
Is a tent city up in the woods on your property? Is that similar? It's not quite in somebody's unit, but you know, there's some problems over in the corner of the property.
It's allowing it's like a temporary residence on the
Right.
property, and those are usually restricted by the governing document. So I mean, you could cite the owner and try to compel the owner to have to take care of this situation, and have the squatters or the temporary encampment removed from the property. But it's not an easy or quick process.
Right.
And it's not inexpensive.
Yep. Okay.
Yes.
All right. You like what she's putting down here? Reach out to Amy if you got any questions. Here's her email, phone, email is amy@laurellawgroup.com. Phone's 206-745-2044. And you can check her out at laurellawgroup.com. So if you have questions, reach out. She will be happy to talk to you. All right, current issues. What are the hot button topics right now in the post-COVID era? And you know, we've got some bullet points up there, but what are you seeing that it's a little different?
Yeah, you know, it seems like COVID and the lockdowns, it's really had an effect on people and people's ability to live together. So when we're looking at our HOAs and condominiums and people living closely together, it's been there's been a huge uptick in non-compliance. You know, we have pets listed there. It's like, well, what does that mean? It was really interesting as we got closer to the holidays. Things really started to heat up, and I had 2 different condominium associations, like within a week or 2 of each other, experienced the same issue of the owner allowing their pet to urinate and defecate on the deck, and it was dripping below to the condo units and their decks below.
Was this during the freeze and it
And
was kind of cold and they didn't want to go out and they just let him poop on the deck?
it was right before that. So
Oh.
I don't know if it's you know, if it was just I'm lazy, I don't want to walk my dogs. Who knows what the situation was, but you know, the association had to get involved and have everything cleaned up and professionally cleaned. I mean, owners, you know, neighbors were upset. I mean, they saw urine on their cars or urine on their deck railings, and
Right.
it was actually pretty gross. So you get that kind of behavior. We've had some interesting and troubling behavior with rental units, holdover tenants who just increasingly, I believe, but I can't confirm, they were using drugs. They were and they were becoming mentally affected by that, punching holes through the unit into the neighboring unit walls, accessing the attic space. We actually had to connect with you, gents, for that one, to design something to secure those attic spaces, because this tenant figured out a way how to get up through the attic space and crawl over into the neighboring unit. He was stealing things. He would enter the unit in the middle of the night while
This is going to freak everybody out. You know, that attic access hatch you have in your bedroom closet or your laundry room closet. This guy was going up through his, crawling through the attic and then finding yours and crawling down into yours and stealing your jewelry and who knows what. Creepy.
It was really creepy, and the thought of, you know, I mean, not just what he was doing, but what he could be doing
What
or
it
could have
could do.
done.
Yeah.
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 That was really disturbing. So we're seeing a lot of bad behaviors between
Okay.
owners or tenants. And
I think it's
so
just stress, or it's just, or it's, nobody's gonna, the police can't chase me down anymore, or, what in society, I guess society, all these different levels are playing, and it's just bad behavior is on the uptick, is what you're saying.
yeah, yep.
Wow. Okay.
The authority to borrow, that really stems from, so we've got these older associations, and as you know, associations are aging. Oftentimes they're under reserve, so they haven't done the reserve studies or adequately funded the reserves throughout the years. And so now they have this major, we've discovered we have all this damage, and while we're trying to recover, hopefully insurance to cover a portion of it, we're going to need quite a bit more money. And in order to effectively repair the condominium, as you know, an association really needs to do the entire repair all at one time and really not wait for several years to, collect a lump sum special assessment from owners.
Right.
So the authority to borrow in the governing documents is, I've seen a lot of that. So, obviously more with the older associations than the newer ones.
Mm-hmm.
Then of course, some owners get suspicious. Well, we don't want the board to have the authority to borrow. And it's, so you explain the process, right. And it's like, well, yeah, subject to owner approval, that kind of thing. And it takes a little bit because they're on edge,
right.
Now you want to push this envelope and have more authority to do things. It's like, well, we need to make repairs and we need to have the ability to do it. We don't have $1.2 million in our reserve account. So, we gotta figure out some other ways to get this done.
I haven't sat on the inside of that discussion, so that's good to point out. It's not only is there, there's always, what's this new board going to do? And I'm wary of them, but now I'm giving them approval to go get a loan without my approval. And so, yeah, as board members or managers kind of talking about that, well, it's got strings attached to it, and here's what it is, and here's what it's for. So,
sure. Yeah. And, we do, in drafting those types of amendments, a couple of important things. One, both legally and then per requirements of any lender who will give, it's a commercial construction loan to an association. There's certain language that absolutely has to be in the governing documents in order for the association to even be able to get a loan.
Right.
But then, understanding too, the language in there isn't like this carte blanche. Hey, we can just take out a loan for $1.2 million without any owner oversight and approval. I mean, there's, the association can apply for the loan, but then it has to present the information, have the owners vote on it. So it's not just a carte blanche
Right.
ability to borrow money.
Yep. Okay. Yep. All right. So this slide, cost of an attorney, this is just more of a real quick high level. And it comes from, we'll get it from older communities saying, I have never used an attorney. I'm trying to get my budget up to speed. I'm watching your videos, gents, and I need to set my reserve study right. And so in that reserve study, we got to have a line item for legal services. And so can you give us some kind of bracket of just, hey, can you help us, in year one, get it sorted out and kind of up to speed? And then maybe year two and on, there's some kind of ongoing average. I know we can't, special projects can take a life of their own, especially pee and poop all over cars. And those are special projects. But as far as what would you tell a board saying, look, just put 10 grand into your budget or 5 grand, something, what would you tell them?
Sure. Well, obviously, like you point out, you go from, an attorney or an association really hasn't had much or any guidance from an attorney versus maybe they haven't consulted with an attorney in a couple of years, but for the most part, they've been up to speed for most things. So you have a really broad range of getting things sorted out and up to speed. If you have a hot mess, I call it a hot mess because it's like everything really needs to, some major work. There's a lot of issues and it's going to be time intensive. I mean, you can look at 30,000 plus in attorney's fees
Sure.
to get things sorted out, get the CC&R amendments that are necessary. And sometimes it's CC&Rs, bylaws, and rules. I mean, it can be the whole gambit of things. Getting the board to adopting the budgets appropriately, and helping them get that all set up. So it can be a real hot mess. I mean, if if you're on the other spectrum of things, I mean, maybe $5,000, give or take. I mean, it obviously is just case specific, but
right. Are these expensive reviews and revisions of bylaws and really getting us cleaned up from the last 20 years? Can we take that out of reserves? It's kind of, or again, you'd have to review those documents to say what can reserves be spent on. So 30,000 might be hard to put into a budget.
There's state law governing the reserves, and the reserves are for maintenance, repair, and replacement of the common element facilities of the association. So if there is something, however, if there is something that the association has an urgent thing come up, and they need to pull out a chunk of money to have an attorney help them out, they can do that, but they have to propose replenishment of those reserves in, I believe it's a 24-month repayment schedule, unless the board determines that that's a huge detriment to the homeowners. So it's a possibility, but again, working your way through the things. Right.
So all right. Common bylaw revisions, and we're not going to read the fine print, folks, but just these 4 items. Amy said these are the top 4 things that I would really, if I just had limited time to help you with, I would just immediately go here. So why don't you break those down for us?
So I've had a lot of requests for rental restrictions in condominiums, and associations, condo associations have had just so many difficulties, particularly with tenants. And there's been many studies done with respect to tenant occupancy versus owner occupancy. And those studies find that tenants tend to violate the governing documents more often. They tend to, just kind of put more wear and tear on a unit and the surrounding facilities and owner would, because it's not really their problem per se. It's, it's just a rental. Governing conduct or giving the association options for enforcing against tenants and authorities. So for example, if you got this crazy tenant who's punching holes in the wall and accessing the attic space, if the owner's not going to take action and have them evicted, the governing document should give the association the right and ability to do that.
That's a good point.
Yeah, because unfortunately, sometimes you get an owner who says, oh gosh, I don't want to deal with this. I don't know how to do it, or I don't want to pay the legal fees to do it. Then the association has to step in, and sometimes it can get fairly urgent.
And so you're even saying if the association has to step in and do that, to back charge the owner. I mean, this is
right. And that's the other piece of it, is specifying that those fees and costs will be an assessment to the unit owner to ensure that the association is protected with all respects on that.
No.
Yeah, rental restrictions, are a big one. We talked about authority to borrow. That's been a pretty big one. And, the aging buildings and need to be able to borrow money to cover significant expenses. Shifting provision for insurance deductibles, and uninsured expenses. So a lot of older associations governing documents are don't really cover that topic very clearly. And the best way to prevent an argument is to have clear governing documents, clear language that says, yes, owner, you're responsible for the insurance deductible and any uninsured expenses if the loss comes from your unit, for example.
Right.
So and that and so that has become really popular, and because there's been an uptick in insurance claims with aging buildings, you got lots of water events that can increase the cost of the insurance. So oftentimes the association has to increase the cost of the deductible to reduce or keep the premium at a reasonable rate.
Right.
And then recovery of attorney's fees. Some associations do not have not even a prevailing party attorney fee recovery if there's like an enforcement action and they file a lawsuit. But even pre-litigation, the CCNRs really need to address that, particularly with enforcement. It can be very unfair if a board finds that an owner has violated the governing documents. They've been asked multiple times to comply and they fail to do so. An attorney is hired to help, the situation and hopefully get compliance. And for all the owners to bear the cost of that and not the responsible party is pretty unfair.
Right. Yeah, I think what a lot of people don't understand necessarily is that when the developer goes to build the community, the developer is the board until enough sales have happened. So then the HOA assumes the board control, and now the developer is not the board anymore. And so there's that transfer of power. And so for the first however long, these are the developer's bylaws. And so you'll see some, horrific comedy of just, you can't sue me. I'm in charge and this is my condo and it's not old, so you're not going to need any maintenance and, whatever insurance stuff that happens later. So I'm not going to talk about it. And so you'll get this document. It's like, whoa, wow, that's not written for the association. That's not written for the resident board and association to run it. And so actually revising these documents and then getting these things in there and making it not so one-sided to the original owner or developer. And so.
Right.
Yeah.
Absolutely right. Yep. It definitely hamstrings an association and,
Mm-hmm.
often needs an amendment to sort it
Mm-hmm.
out for sure.
And we've been talking about number 3 for the past few months on this show. And so this shifting provisions, and sometimes just think of your deductible right now. So sometimes your HOA deductible starts at $25,000. And so do you want a way to, hey, I don't want to have to pay that every single time. If they knowingly cause something, they should be paying for it. And especially if I have to equip up to deal with a person not behaving well, they should be paying our attorney's fees, not the residents that are all abiding by the law. So boards look at these things and, top 4 things that probably every one of your bylaws needs to look at and needs to think about. So finding a great attorney, not to go through every interview question, but what Amy, what's your perspective on how does a board go about hiring a good HOA attorney?
Oh, obviously you want someone who does have experience in the field, not just a real estate attorney, but someone specifically experienced with community associations. It's a very niche area of real estate law. have the attorney talk about their experiences, what kind of amendments have they drafted, or what kind of, cases, if it's litigation, what kind of cases, have they taken to court? Those kinds of things. You want an attorney that the board feels comfortable with. They can discuss the issues. They feel like the attorney is receiving the information, but also able to, it's the legalese, the translation of the Sanskrit governing documents that you've been trying to figure out, and and how it all works. Sometimes community association attorneys have to make presentations to the members, and helping the members understand and support a proposed CC&R amendment. So, so you want an attorney who you think would present well that way. We have support staff. A good association attorney will have support staff. They're often the right arm of the attorney in terms of moving things along, connecting with boards and property managers, like for collection issues and that kind of thing. And another thing, we don't have it down there, is that you want a community association attorney who's responsive. I really try my best to respond to emails, and I get a lot of them from property managers and board members within 24 to 48 hours. Having an attorney who's super responsive to help keep things going, address urgent issues, is really critical in this area of practice.
Okay. All right. There's some interview questions for everybody when they go to talk to hiring somebody. Okay, let's get into the nightmare stories. We probably got about 5 to 7 minutes on this, and then we'll jump into Q&A. Do you want to set the table for this one we worked on, or do you want me to? And then here's some other issues around that. But
yeah, well, sure. We'll just jump right into it. So this is when it was an older condominium and needed significant repairs. I think it was upwards of $6 million worth of repairs. So it was quite a bit. And as anyone can imagine, that would freak out the membership. However, this was also kind of a rowdy crowd. And so it was difficult to be reasonable with them. And although this association, I think they did a pretty good job in trying to coordinate, here's our experts and here's the presentations. It seemed like there wasn't quite enough time for these owners to digest it. So when it came to the vote to, do we proceed with repair or not? You have to vote to repair or not repair. They decided they would try to avoid the special assessment by voting not to repair the damage to the condominium. And that in turn, so that was 67%, which is quite high. That was the approval or the percentage required to vote against the repair. And so unfortunately, that in turn disbanded the association. So what that meant is, instead of having this association entity subject to the Condominium Act, these owners were now tenants in common, and they were also all responsible for communicating with each other about repair of their building and landscaping, maintenance issues, all of that stuff. So it was really not a good thing at all for this association.
Yeah, the rowdy or the mob mentality sounds really good when, on one side of the coin, it's, heck no, we're not going to do this assessment. And then on the other side of the coin, hey, wait a minute, who's now in charge of mowing the lawn? Because the grass is kind of long. Are we supposed to mow our 1/64th of the lawn? And you're not doing your part. And why doesn't my cable work? Who's paying the cable bill? Oh, we all have to get cable now. Oh, darn. Ooh.
Yeah. Oh, who's going to insure us in this situation?
Right. How do we pay insurance?
It's a really tricky situation. And so the board was very proactive about getting the condominium status reinstated. They had to get 100% consent of each and every owner. And that took time. It took
That's
some
hard.
of the owners had to be taken to court because they just wouldn't respond, or they were like, well, that's your problem, I don't care. And so we had to have a receiver appointed in those situations. And so it was an expensive and an uncertain process, because
Mhm.
we didn't know if we would get this thing reinstated. And fortunately we did. And then,
But
as you
it
know,
took 8 months to get it turned back on again.
yeah, I would say
Okay.
at least 8 months. It wasn't a quick and easy
They
process.
lost a year of time, and I don't even know how much money. I mean, can you give us a magnitude of to
I would say,
disband and to reband? Is that $100,000 request?
yeah, I was, I was estimating it was probably around 90,000 in fees going through that whole
Wow.
process, and the, couple of lawsuits against the owners that we had to deal with.
Mhm.
It wasn't cheap.
Right.
And, it really seemed, there were a lot of rumors going around with this association, that mob mentality,
Mhm.
and information was presented to an effort to calm the owners and clarify what's going on.
Mhm.
And, it was just, looking back at it, perhaps more town hall style meetings,
Right.
so not necessarily like a special meeting, but providing
Informational
information
meetings. Yeah.
from the experts in advance to give the owners time to digest.
Right.
But at the same time, when you hear that there's going to be this giant, it's all this damage, this giant special assessment, even with recovery, they had a decent recovery on their insurance claim.
Mhm.
Even with that, they were still completely freaked out.
Right.
And so it's a difficult situation for sure.
Mhm. Yeah. So yeah, kind of be careful what you wish for. It's that we've actually seen that. And I hear some, hey, what if we just disbanded this condo and did it on our own? And I was like, whoa, watch out, watch out. There's lots of things to think about. So let's see, covering any of those. Yeah, we kind of covered about this type of stuff, but we're seeing this more and more in the news. The video picture clip there, HOA says remove the bench or they will. And obviously, an elderly man with a cane probably likes to sit on the bench outside, but just understanding, can I put a bench? Does it need to be removed? Do I have authority to sit out there in the lawn? And then just are we running a police state, or are we running a community where everybody wants to live? And that's some of that balance that
Sure.
HOAs
Yeah,
have to do.
it can be hard to balance, here's what their duties are, and here's what they're
Mhm.
responsible for doing versus,
Mhm.
the poor little man wants to sit on his bench, outside his unit, even though he's not supposed to have that there,
Have furniture.
and yeah.
Yeah. Yep.
So,
All
um,
right. Oh yeah, go ahead.
yeah, no, I was just addressing, we also look for, like, talking about holes in contracts. Again, I'll point to the attorney's fees, but other adequate protections for the association. I think one important thing that comes up, and it ties into issues with insurance coverage.
Mhm.
So, like, when we do these big repair projects that you and I get involved in, I like to see an all risk or a builder's risk policy.
Mhm.
I think that's
Mhm.
super important because it'll cover damage to not only the building, or if it's a non-employee who gets hurt, but also like the construction materials. Let's say
Mhm.
they're stolen, or let's say there's a wind event and it destroys the materials that you want to install on the building. Well, those aren't covered by the association's insurance, and they're not covered usually under the general liability policy for the contractor. So it's really important to have those kinds of things
Right.
when pursuing these projects, to ensure that and it covers all parties involved. So it's not just the association, but it's also the contractor. So it's definitely something to negotiate in those situations with the contractor, to make sure that there's adequate protections.
Yep. Builder's risk. Yep.
Yes.
Okay, is any of this stuff sounding familiar, or do you think you might have an issue? Do you have people climbing up into your attic and climbing across your bedroom ceiling? No, I'm sorry. Didn't mean to scare you. So use this link, set up a 15-minute call with me to get some specific advice for your building, and it's free. You can use your phone, scan that little QR code, or you can go to learn.j2consultants.com, consultant on call, and find a time. So now's the fun Q&A time. Ding, 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 ding. And I see 5 questions and answers. Oh, okay. We have the first attorney joke. You ready? It was so cold that I saw a lawyer with his hands in his own pockets. Ba-dum-bum. There you go. The one that comes up is the sharks. Have you heard the sharks? Why sharks don't eat lawyers? Professional courtesy. Dun-dun-dun.
Yes.
Yeah, okay. All right. I won't pick on it. All right. The next real question here is from Phil. What is involved with an attorney review of a condo re-siding contract? What involvement is expected from the property manager and board managers? And what are the timelines for each party's involvement?
Yeah.
You want to take a stab at that?
I will. There's quite a lot there, so I'm not sure if I'll be able to unpack it completely. So you want to make sure, so what's involved on the attorney's end, I think, is making sure that the provisions are consistent with what's needing to be repaired. The pricing discussed, we talked about adequate protections there. We look for indemnification clauses. We look for proper insurance coverage. We look for commencement dates and estimates as in terms of when will this project be completed. And then, who will handle, usually the architect's involved in like handling a dispute about, each stage, there's inspections and those kinds of things, how payments will be handled. What's considered project completion, and then you go through your punch list. So there's quite a few things we're looking at,
right?
In terms of, what's expected of property managers. I think that is just, it's the information between the board and the attorney, and and any information related to the project that they would have that may be necessary. The attorney would ask for that information. Usually the attorney is involved so far in advance of that it's not, they already have that information. So
or boards that are with it. Yep.
Yeah.
So things that come to my mind, attorney review of a condo re-siding project. So the attorney, are they looking at a dime store contract that's, pink, yellow, white, and they've handwritten some things in there? Or are they looking at a nice standard of contracts like an AIA, family of contracts? Or is there a reasonable, homegrown contract that protects both sides? And so is it something they've already looked at before? Is it something that they really have to plow through? And so that would affect all that. What involvement is expected for the property manager? Well, some managers, according to their contract, do or don't review, vendor or construction contracts. So double check with them. And then some managers take I can do this, I'm experienced. Others take I'm not a lawyer, I'm going to stay in my lane. And so you gotta find the right people. So timelines, even, a day or two to go through a contract and then, work it into your current schedule. So, but it is a little process because we want the board to be looking at it. We're going to look at it from constructability. We're going to ask the HOA attorney to look at it from condo law and governing document angles. And then we want the board to really look at it too, because there is some talent on the boards. So hopefully that answers the question.
They often come up with some really good questions. Hey, what does this mean? Or is this right? I'm concerned about this clause. So it is really good for the board to be involved, especially.
Yep. Okay.
Yep.
All right. Next question comes from Coy. Are there common fee structures with HOA attorneys? And what should we try to get negotiated up front? I feel like I get charged for every email written to our current attorney, even for general questions that don't require much research. And so, yeah, the fee structure thing we talked a little bit about last month. This appears that it's a time and cost. So for all the time that is spent, and I have to write an email, as opposed to a set fee or a monthly fee, or I'm going to handle all these questions for X amount of price, or, what type of input would you give on that, Amy?
Sure. So for the most part, with community association attorneys, we have hourly rates, and those would apply to contested matters. Different rates, though, different hourly rates, though, for collection versus enforcement, or maybe a different kind of legal action. So because in the collection work doesn't command as high of a rate as other legal matters. We do have flat fee rates for specific collection type of activities, lien recording, lien release fees, demand letters, that kind of thing. But for the most part, all the other work is based on an hourly rate. I know, it can be frustrating or seem really expensive. Yes, you get charged for, an answer to, in an email or a brief phone call for, asking questions and asking for advice, but we are, setting aside the work that we are doing. We're opening up the email and thinking about the question. Sometimes it's a quick reference to the governing documents. But think about doing that throughout the day. We're providing a valuable service to our clients. And if we don't charge our time for it, we have to make money. We have to survive somehow. And that's our part of our, that's our legal advice. And you rely on our legal advice. So if we don't give you the correct legal advice, that's not a good thing either. And that we can be held accountable for that. So, that is part of our service, and, we do charge time for it. So just in terms of negotiating, I think that attorneys do try to provide estimates on what certain projects will cost. It's certain things are difficult, to estimate, though. I mean, sometimes you think you're getting into an amendment project that seems fairly straightforward, and then there's more complications with the governing documents that you may not have been aware of, or just the board has more things that they pile on, and so what was estimated versus what is actual, just it can vary.
Okay. Talking about those two types of usage and lump sum fees. So and talking to your attorney during that interview question. Or during the middle of it. Hey, we're going to be working together for the next 6 months. I'm tired of feeling like I'm nickel and dime. Can you just charge me a flat rate? And that way I can put it into the budget and we don't have a problem with it. So, Okay, next question comes from Anonymous. Amy, do you have a standard billing rate list available for relatively standard things? And I think that would be kind of more in the business transactional, wills are 3,000, this is 2,000, this is 1,000. But do you have anything in the condo world of board bylaw revisions? And if you do, then it's something that I'm assuming you'd talk to them directly about. But is that something that you can kind of put pricing?
I can put together. I do have like I said, I have a flat fee rate schedule. It's primarily for collection matters. For amendments and other types of things. I mean, obviously I'd have to review the governing documents to put together an estimate. And so that takes a couple of hours. I charge $350 an hour. I mean, just to kind of, take a look at what I'm getting myself into. I estimate it's going to cost, between $3,500 and $5,000, that kind of thing.
Yep. So you can give a budget. Okay, great. Let's see. Next question from Eric. Have rental cap restrictions been tested in the court system all the way through to removal of a tenant that is renting in violation of a rental cap? So I think what he means there is rental caps are capped at 20% of the units. We have 25% of the units. And so, the first question pops up. Okay, which unit is the 5%? But I guess that first question is rental cap restrictions, and can you evict the tenant who is in violation of that?
Yeah, honestly, I think it's a little more difficult these days, now that we have changes in landlord tenant law that greatly
Mhm.
affect, the landlord can't evict them, it's gonna be difficult for the association to evict them. And essentially, I think there's different approaches and strategies to that. But to get it tested all the way through, um, I I'm just trying to think if I've ever had a case where I've had to do that. I mean, I've had to evict a tenant, but that was before the law changed. And it's whether the court finds that the governing documents are enforceable, that the restrictions are valid and the association has the right to do it, the procedures were followed. And then, so for example, if the tenant's committing waste or they're a nuisance to the community, and you can show strong factors that this is, maybe it's not just the rental cap, but it's also
Violations
the
of something.
tenants. Yeah, that can really assist the association. But there may be sort of a backdoor mechanism, impose fines against the owner. And maybe they're looking at, because they can't keep up with the fines and the things that are going on because they violated, well, maybe they're in a situation where the unit will be foreclosed. I mean, that sounds really
Mhm.
mean, but strategically, that
Yeah,
might be.
so kind of an end around. So it's not necessarily the tenant in court, it's the owner being fined to death because they're not following bylaws. Yeah. Okay. Well, see, here's why you should talk to Amy. Okay. Last question comes from Anonymous. Oh, do we have another one? No. So Anonymous is asking about window replacements. And we've talked before about what happens when the board allows, or the HOA allows residents to replace their own windows and they do it wrong. And then the third story damages the second story and the first story because water flows downhill. So the question verbatim is, if the HOA allows owners to replace windows, how would they know if they were done right and who is responsible for the walls? And here's an answer I got today from another attorney. The short answer is that if the HOA is currently responsible for the building envelope, it doesn't really matter what past owners did and how it impacted the envelope. So what are your thoughts on that?
I always thought it was risky, and I think it's risky to permit owners to replace windows because it does impact the building in so many ways, that could be very negative, not just to that unit owner, but the owner maybe below.
Okay.
And cause more damage to the building envelope. So really the most effective way to control that is to require that, or just the board is, establish that is an issue that the association must address and to do the repair.
Right. Yep.
Because
Okay.
that's the ultimate protection. Yeah.
Okay. All right. All right. Thanks everybody for the questions. Those are good. Now we get to go into the giveaways, and everybody's excited for this. Let's see, we've got some more J2 brew. That's a very nice item, but now it's starting to get sunny. So we've got some J2 sunglasses. We've got, I'll call this the lazy river or boating drink cup, and you'll like it so much that you'll rinse it out and save it. So Amy, do you have any giveaways today?
Yeah, I'm going to do a $40 gift card to Starbucks.
Nice. All right. Well, why don't you pick first? So we've got 16 participants. So pick a random number in that list. And
was that 1-6?
Yes.
16. Okay.
And so pick a number, and everybody's listed out in the webinar thing. And then Brooke and Ben will reach out to them and send them your gift. What is your number?
It's number 7.
Number 7, lucky number 7 gets the $40 Starbucks gift card. That's a good one. Okay. And so you picked 7. I'm going to go 11 for this one. 7 and 11 are the winners today. So We've done the giveaways, and stay tuned. If you're one of those numbers, Brooke will chat you and get your address and things like that necessary to get your prize. All right. So did you know we have free resources for boards and managers? Just more of this stuff. Go to learn.j2consultants.com/resources. On YouTube, we have over 300 videos, and we can answer a lot of your frequently asked questions. And don't forget, we'll be back next month, 3:30, last Tuesday of every month. Scan here, invite your friends. April 25th. We will be training your residents so you don't have to. It'll be a general thing. I don't know that I'll have guests next time. We're going to be talking about things all condo owners should know. So just very broad things, but following up on our questions. And then the following month, April, May, we talked about bad behavior this time, and May is Mental Health Awareness Month. And we're going to have some licensed counselors on to talk about how we deal with mental health issues that we're seeing, and to steer the conversation away from policing and cracking down to how do we help these people? How do we communicate well? How do we create a community that we want to be proud of being a part of? And that's, sometimes bringing along people that need some extra help. So that'll be a fun one too. All right. Thank you, Amy. Here's Amy's contact information again. Do you have any parting words?
Hey, I just want to thank you again for having me on. It's been a lot of fun, and I do enjoy working with my boards and property managers and solving whether it's difficult or fun problems. It's always very interesting for me. So I really do enjoy that. And I hope the information today was helpful.
All right. Thank you again. And thanks everybody. Have a great rest of the afternoon.
Thank you.